Morning, everyone. Welcome to the last Q&A of 2024. It's good to see all of you. I'm going to wait just a couple moments to allow everyone in from the waiting room. And it looks like we're good. So welcome. Thank you for joining us today. I know a lot of you are getting ready for the holiday season and or dealing with issues from the storm last night. We lost power for a little bit. So I hope all of you are doing well. We're going to start out as usual with our Zoom housekeeping tips. We ask that you all stay muted unless you're going to ask a question. Muting makes sure that everyone can hear and there's no feedback and background noise. If you don't know where your start and stop video or mute and unmute buttons are, they're usually at the bottom of whatever device you're using. So I'm going to skip over that because we cover that pretty much every week. This Zoom Q&A is meant for general legal information. It is not legal advice and should not be treated as legal advice. If you have a specific situation that you need advice for, please contact your association attorney. This Q&A is just to give information that should be that's hopefully generally applicable to many communities. If you have a specific situation, you need to contact your association attorney to get specific advice for your situation. And the same thing, if an owner or another board member comes to you and says, condo law said X, why are we doing Y? The answer is the Q&A is just information. It is not legal advice. If your specific action is based on legal advice, you can just say, this is what our attorney said, given our particular circumstances. And we have had that come up a couple times where we told a board a certain thing based on their governing documents and their specific situation, and then had an owner challenge them based on something in the Q&A. So it does happen. Just be aware that the Q&A is general information, not legal advice. So we're still getting a lot of questions regarding the CTA. There's at least one today. Enforcement is temporarily blocked due to an injunction filed in a Texas federal district court. The government filed a motion to stay the preliminary injunction. And if that motion is granted, enforcement will be permitted again. National CAI filed an appeal to the Fourth Circuit from the denial of a stay, as well as an amicus brief in the 11th Circuit. So there's still a lot of litigation going on in a couple federal circuit courts. There's our recommendation to our clients has been to just comply. It's the lowest risk, easiest option to take. And the risk associated with failing to comply right now is lower, but there's still a risk that the injunction could be stayed or other action before the end of the year, given the litigation in the federal courts. So our advice to our clients has been to just comply. It's the easiest, lowest risk option.
Yeah, let me just add a little bit. Right now, you have the Texas court granting injunction, which the New Jersey court refused to do for national CAI. So you've got different splits. And eventually, there's going to have to be a reconciliation. Either the appellate courts in both districts are going to have to agree with each other, or it'll find its way up to the Supreme Court to figure out which of the different district court decisions are correct. But it's sort of interesting to me that the Texas court would grant the motions that National CAI asked for and was denied in the New Jersey District Court. Sorry.
No worries. So our legislative session will be starting soon. If you are not aware, the state CAI has the Monday morning minute, which is a legislative update for our legislature and our legislative session. Chelsea, could you put that link in the chat, please? If you want to receive the Monday morning minute, it's just a quick email giving you an update on what's going on in the legislature based on community associations. So this is good information to have. There will be calls to action as well. So if you want to answer one of the calls to action and lobby one of the legislators, or even testify in front of the legislature, that would be contained in the Monday morning minute. It's, as I said, good information to have. It's very timely. So if you signed up in previous years, that sign up ends at the end of the legislative session, so you have to sign up for it every year. And moving on, for our clients, our fee schedule is changing as of January 1st. Work ordered before January 1st will be at our current rates. Work ordered after January 1st will be at the new, will be under the new fee schedule. So just a quick reminder, there will be no Q&A for the next 2 weeks. We are not going to do that for Christmas Day or New Year's Day. We're going to spend time with our families. So we look forward to seeing you all in the new year. And then we have very few questions today. Most people are probably gearing up for the holiday. So if you have questions, please put them into the chat and we will get to them after we've finished answering the questions that we've prepared. Ken, did you have anything that you wanted to add?
No, I'm good.
Okay. So moving on to our first question. When is the effective date of the statute that requires an audit? Is it 2024 or 2028? So the answer to this is different than probably what you're expecting. All associations are either required to have an audit or annually waive the audit from the time they were formed. It's in all the statutes. Whether a particular association can waive the audit requirement depends on which statute you're governed under. So for Old Act condos, 6432-170 sub 10, this is from 1965. States that all books and records shall be kept in accordance with good accounting procedures and be audited at least once a year by an auditor outside of the organization. Then in 1990, when the legislature adopted the new act, and this particular provision applies to Old Act condos as well. It's found in 6434-372 sub 1. And then this is where it states the financial statements of condominiums consisting of 50 or more units shall be audited at least annually by a certified public accountant. If the association has fewer than 50 units, the annual audit is required, but it can be waived by a vote of the owners, and it requires 60% approval. So then 6438-045 sub 2, this is in 1995. The legislature had all HOAs with annual assessments of $50,000 or more shall be audited at least annually by an independent certified public accountant. The audit may be waived if 67% of the votes cast by owners approve waiving the audit, and that's an annual vote. And then for any community under WUCIOA or a WUCIOA community in 2018, the legislature under 6490-530 sub 2 states that associations with annual assessments of $50,000 or more must be audited at least annually by a certified public accountant. And then if the association has less than $50,000 and an annual budget, they can waive the audit by a majority of the votes cast in person or by proxy at a meeting. So the legislature definitely favors having audits. They are required for condominiums not under WUCIOA of 50 units or more. but can be waived by a 60% majority of the owners for those condos under 50 units. Then $50,000 or more for HOAs, but you're required to get 67% approval to waive the audit for those associations under $50,000 budget. So, and I'm losing where I'm going with this. I'm sorry, Ken. Did you have anything to add to that?
Yeah, a couple things. One is if the question is really about when does the requirement under WUCIOA for an audit start applying to all communities, which is going to replace all of the ones under the condo and HOA statutes. The statute becomes effective on the first day of 2028, and it requires an audit. So the way we read it, you would have to do an audit in 2028 for the fiscal year 2027 because that's what the statute reads. And the other comment I'd make is that we have a lot of communities who think that because they find the audit requirement onerous or expensive or unnecessary, that they just don't have to do it if they don't get a quorum. But in order to waive the audit, they have to get a quorum for their annual meeting as a first step, because you can't take any action without having at least achieved a quorum. And you probably, even if you have a quorum, may not be able to get enough votes to reach the 60% threshold if you're a condo. That trigger anything else for you, Jennifer?
No, I'm good.
Okay. Well, the next question. The homeowner association is required to maintain a reserve account for long-term building maintenance repairs and replacement items identified in the reserve report. Is the board allowed to spend reserve dollars on a superfluous item such as a camera system that is not identified in the reserve report? So there is a requirement for reserve studies. I'm going to assume that the question means reserve study. There are statutes that basically state that if you spend money for something other than a repair or replacement of a reserve component as defined by the statute, that you must notify the owners and have a plan for repaying that money within 2 years unless it would create an unreasonable hardship for the association. So I'm not sure I would use the term superfluous for something because I'm not sure if that's a pejorative term saying it's unnecessary or imprudent, or if it's actually intended to just say it's a new component that doesn't exist today. And so if it's a new component, meaning you don't have a security system, you want to add one, then I think that it would require following the statute to give notice to your owners and have a plan for repayment. It might also require that you comply with a declaration provision, which is very common in condominium declarations that require affirmative approval by the community for a capital addition or improvement. So if you have no security system and you want to install one, then it's probably a capital addition or improvement, and it would require both an affirmative vote under the terms of your individual governing documents, and it would require notice to the owners that you've spent the money on that system and a plan to repay it. Though I note that under the statute, there's not a requirement for the board to get approval for that new security system. Anything you want to add, Jennifer?
I think I'm good. So the next question is, at the annual meeting, when an association is voting on whether to waive the audit, is an unreceived vote a no vote? The answer is yes. All the audit statutes require the approval of either a majority of all owners in 6490, 67% of owners in 6438, or 60% under 6434 and 6432. So unlike budget ratification, waiver of an audit requires the affirmative vote of the required percentage of owners. It's the same as a declaration amendment. So if an owner chooses to not vote, then that's counted as a no. I'm going to take a couple quick questions from the chat if you're okay with that, Ken. They're on the audits.
Sure.
So it makes sense to do them all at once. And the first question is, how is the audit requirement regulated by the state? Is there a penalty for missing a year without vote of the owners? There's really no penalty, and the state doesn't regulate that. However, owners who request documents or association records will have to be told that there are none for that particular year. How that's handled by the particular association, I'm not sure. This really hasn't come up in any cases in front of the court system yet. But if the statute requires an audit and the association fails to do so, that could be the board not following their duty of care. It really depends on the particular situation for that particular association. So our recommendation is just follow the statute. If you haven't in past years, make sure that you follow the statute now that you're aware of the requirements. Ken, did you have anything to add to that?
Well, I would say that for almost everything in the statute, there are no penalties described, and there's no condo police out there trying to make sure that associations are complying with the requirements of the statute or their individual governing documents. And so it is the sort of thing where the membership and the board self-polices, and sometimes you don't know what risk there is until something bad happens. So we happen to have, a client a couple of years ago that had lost more than $500,000 to theft of association funds spread out over a period of, I think it was 8 years. And if there had been an audit, perhaps that would have been discovered earlier. I don't know if that's true or not, but the reality is the audit is a double check of how the finances are being done, and it's a way to assure the owners that the funds are being appropriately kept and accounted for. But yeah, there's pages and pages of statutes that require boards and associations to do things, and no one except for the parties involved, which is primarily the board, trying to make sure that they comply. Few statutes have an actual remedy written in them. So, for example, the reserve study statute has a specific remedy on what owners can do if the board does not have a reserve study done. The same remedy is not provided for in the CPA audit section of the statute.
Okay, next question is, I need clarification with the WUCIOA audit. Is it required to send out paper ballots to homeowners to waive the audit, or do homeowners need to attend the meeting to cast their vote in person? So voting is under a different statute, so follow the voting requirements under 6490. I don't have that statute off the top of my head, but any vote that you can take at a meeting can be done by absentee ballot or do a vote by mail. So whichever procedure you're using for your audit, for your meeting, you can add another vote, line item vote for the audit as well. Ken, did you have anything to add to that?
Well, I was going to get back to the question you were answering if you're done with the audit questions.
Yes.
Okay. So in terms of trying to decide whether a no vote is the same, or a failure to vote is the same as a no vote, it may depend on the kind of vote that you're taking. Because if you're doing a vote which is to get 50% of all owners, then it is true that a failure to vote is the same as casting a no vote, because what you need is a specific number of affirmative or yes votes. But if you're voting on something where the pool of votes is just the people in attendance at a meeting casting ballots, then you've got a whole lot of people who are not attending and they are not they are not failing to vote, but their votes are not considered. So if you're trying to get a majority of a quorum, the failure of people to show up and cast their votes do not count as no votes. You're only counting those votes which are actually cast. And so you have to be sort of cautious in looking at what the requirement is. And I think under the Condo Act, if you need 60% of all owners, then a failure to vote is the same as voting no to waive the audit. But if you're a homeowners association act organization and the criteria is 67% of the votes cast at the meeting with a quorum, then the failure to vote is a non-event. So, anything else you want to add on that, Jennifer?
No, I think we've covered it.
Okay. For the most part, what I see is clients failing to get audits because they don't know they're supposed to do one, rather than taking an affirmative step to choose not to do an audit or get the vote not to do an audit. So there's a risk that a association is going to have an owner discover their failure to do an audit and file some kind of complaint against the association. Next question. If an association has invested reserves that create interest income, is there an RCW that prevents them from using this interest income as operating income for the following year? Okay. So no, there is no RCW that addresses how the interest income on investments are handled by the association. And I think we've talked about this before on whether or not the interest income is part of the reserve account or part of the operating income. And our opinion was that just as every assessment that comes in starts in the operating account and then is transferred to reserves, the interest does the same thing. And in part because you're going to have taxes on the interest income, which is earned as well. And what you don't want to be doing is trying to put all the money in reserves and then pay your taxes and be required to send notice to all your owners that you've used reserves for some other purpose. So, our view is that the money that comes in from all sources goes to your operating income account first, and then it gets transferred when the board determines it's appropriate into reserves because you have a surplus or because you're meeting your budgeted requirement for contribution to reserves. Anything you want to add on that, Jennifer?
No, I think we've covered it. Next question. Assuming the Texas injunction fails and FinCEN institutes a new deadline for beneficial owner reporting, what recourse or steps does an association take if a beneficial owner that has 25% response or more responsibility willfully fails to provide the required information to the reporting company? So this has been covered in the context of a board member in the past few weeks. It's different when you have an owner rather than a board member. But for an owner that's not on the board, you can follow your enforcement procedures and your governing documents regarding a violation. Typically, the governing documents may have a provision stating that a violation of law is a violation of the governing documents, or violations of law are prohibited in the community. So that's something to look into. But for your particular situation, you would really need to contact your association attorney to find out what enforcement avenues are available to you. And another option is to just provide the Treasury Department with the information that you have, and then let the Treasury Department decide if they're going to go after the beneficial owner for not reporting. Ken, did you have anything to add to that?
No, I'm good. So, next question. We are considering the possibility of substantially increasing our HOA's move-in fees, which are currently $250 and has not changed for well over 20 years. We're thinking of increasing the fee to 2 or 3 months of our monthly assessments charged at the time of move-in. Our governing documents do not address the limit on the amount of move-in fee. We're also considering renaming the fee to a capital contribution fee. I assume this can be accomplished via a vote of the board. Do you have any guidance, comments on this plan? Okay, so we of course have lots of opinions. It sounds like the board is trying to extract additional money from people who are either renting their homes or from new buyers. And I will offer that while Washington State doesn't have cases about this, it has been addressed in other states across the country several times. To the extent that a move-in fee is reimbursing the association for actual expenditures, there is legal support for it, even if it's not contained in specifically in your governing documents. But once you start exceeding the expenses which you could document, then it starts to be you extracting additional money for common expenses from a small number of owners. And so if you start trying to make a move-in fee based on 2 or 3 times the monthly assessment, there is no relationship anymore between the fee and actual expenses. And calling it a capital contribution, I would say, could not work if you're doing it when a tenant moves in. We have supported communities in adding a capital contribution to their declaration so that when a new purchaser acquires a unit, they are contributing to the working capital of the community. And that is I'll say a fee which has not been tested in the courts to my knowledge. So it's very common to have a capital contribution at the first purchase of a unit when the developer is forming a community. It is what funds the bank accounts to allow the association to function. It is becoming increasingly common for communities to adopt a capital contribution every time a unit is sold in order to help with the funding of the association. But if you're trying to just extract money from buyers to take care of reserve expenditures, that is something which the courts in other states have clearly stated is not allowed or not fair, because what you're doing is trying to make a small number of owners pay for the common expenses in a manner different than based on the percent of ownership interest. So if it's something you're thinking about doing, I would advise that you talk to an attorney who can review your documents and determine whether or not you are allowed to do that, and then also help you evaluate whether or not the fees are within the range of what could be supported if you were challenged in court. And in part, I say that because if you have assessed a move-in fee or capital contribution fee and an owner declines to pay and it comes into our office for collections, we are going to be limited in what we can do if it's not explicitly provided for in your governing documents. And when I say governing documents, in this case, I mean the recorded document, which would put an owner on notice that that fee could be expected. Anything you want to add, Jennifer?
No, I think you covered it. So the next question is, a homeowner in our non-WUCIOA HOA regularly and vocally, both in email and in meetings, disagrees with policies and procedures established by the board and our management company. We have frequently revisited his desire to hire vendors and expend HOA funds. It has come up again, probably the 4th year in a row. He initiates contacts with vendors and recommends them to the board. He then objects to the management company's requirements for vetting vendors, copy of business license and insurance plus W-9, refuses to cooperate, and accuses the board of causing delays. He concludes he should be given more authority. what are the options that we have to deal with this particular individual? So I skimmed over some of it. The question is too specific for us to answer as written. In general, individual owners do not have authority to speak for the association unless that authority is delegated by the board and reflected in board meeting minutes. So requiring a business license, insurance, etc., is just the board and association manager practicing basic due diligence and proper risk management. So you can discuss the reasoning behind the requirements for this information and for requiring vetting of vendors at a board meeting when the issue comes up. You can try to educate owners, the rest of the association, on why it's not a good idea to hire vendors that aren't licensed, bonded, and insured. You can, it basically comes down to, you can educate your owners. You can discuss at board meetings why this information is important. If you have an owner who is particularly difficult, you deal with them like any other owner. You can try to follow Robert's rules a little more closely to limit this individual from speaking at meetings. Kind of facetiously, but because we've come up against people like this before, one suggestion is to basically ask this person if they are willing to sign a document stating that they will be personally responsible for any mistakes, damage caused by the vendor, or any investigations by L&I for not being properly licensed and insured if something happens with using their preferred vendor. So that's kind of where the rubber meets the road. If the owner is willing to basically state that, yeah, I will be personally liable, you can point out that in the case of one particular association who had an owner hire a vendor to do work in their unit, the vendor, what happened is the vendor did not hook the toilet to the drain. So raw sewage was flowing into the not subfloor, the foundation. And that cleanup and everything associated with that, the vendor was unlicensed and unbonded, so there was no recourse against the vendor. So whenever you have a problematic owner, there's certain things you can and can't do. And another thing to point out, and we discussed this before the meeting today, is that how many owners are actually listening to this person? If this person is just going off on their own and doesn't have many followers in the association, you can treat them as just blowing smoke. Ken, did you have anything to add to that?
Well, a couple of ideas that work with some difficult owners. One is establishing a policy where you stop being in direct email contact with the owners. So board members cannot individually take any action. They can only function as a board. So we often will recommend a communications policy for clients where there is a specific place and time for how an owner's comments get handled. They typically would go to the manager first, and if they're come in, a week or 10 days before a board meeting, it can be put on the agenda for the board, but individual board members stop responding. And after the board meeting and any decision by the board, then there's a communication back to the owner on what the result was. It is certainly possible and under the statutes allowed to remove a disruptive board member from a meeting. So if they're being disruptive at a meeting, then you can, if it's a Zoom, you can simply mute them or remove them from the Zoom call. If it's an in-person meeting and they're disruptive, you can ask them to leave. You can adjourn the meeting if they won't leave. We've had some extreme cases where we've had boards bring an off-duty police officer to attend the meeting in order to gain some control over difficult owners. If you're going to that measure, you probably should have been consulting an attorney to help you to plan to make sure you're not doing something wrong. But it is a challenge because every homeowners association ends up with at least, one, it seems like, difficult owner who thinks they can run everything the way they want to without being on the board themselves. And so what you need to do is try and find a balance between letting them have what may be a legal entitlement to speak, which is clearly written into WUCIOA, where every owner gets to comment at a board, at a board meeting, or they get a reasonable period to comment, but also not allow those owners to disrupt the functioning of the business and the board's duties. So, anything else, Jennifer?
Uh, just briefly, we have 2 questions left. So if you have questions, please add them to the chat.
So next question is, what is the recourse to take if homeowners believe they weren't given proper notice pursuant to WUCIOA or 6434-384, which is the provision which allows the board to use reserve funds with notice to the owners? So I'm not sure if this is a question from the standpoint of an owner who doesn't think they were given proper notice, or the board, which is now concerned that they didn't give proper notice. So the notice provisions are pretty clear, and at least we think they're clear. If you have not complied with the notice provisions as a board, then our recommendation is typically just do it again. So if you failed to give 14 days notice of a budget ratification meeting, or you didn't send the notice out by mail to owners who hadn't agreed to receive notice by email, or there's some other flaw in the process, our recommendation is typically just do it again because the cost is low, and then you can be assured that you have complied in case there's a need to do a collections action. If you're an owner and you feel like the board has failed to give you notice, then I would typically start by recommending you ask for copies of the records, because your entitlement to records is provided for in the statute, and find out whether or not there really was a compliance issue before you make accusations. Our experience is that most of the time, boards and managers are complying with the requirements of the statute to give notice. And it's not a question of whether or not you got the notice. It's a question about whether or not the notice was sent in compliance with the statute. So if you missed an email, or you didn't pick up your mail, or the mail is slow, those don't affect the validity of the notice which was provided by the association. But if you have failed to comply, and we certainly do run into that on, I wouldn't say regularly, but we do have it happen, and it's often because people miscount the number of days, or they think if they post it on people's doors, that's the same as mailing it. And so we just basically help guide the association through providing another notice, scheduling another meeting, just to make sure that there's not a challenge to the process. Anything you want to add, Jennifer?
No, I think you covered it. And this is the last question that we've prepared ahead of time. So as I said, if you have other questions, please feel free to put them in the chat and we'll get to them after. So the last question, what determines whether or not my community is covered under WUCIOA as it pertains to giving proper notice regarding ratification requirements? So every community in community association in Washington State is required to follow WUCIOA regarding the budget ratification that was put in place when WUCIOA was enacted in 2018. So budget ratification requirements are found under 6490-525, and that has been applicable to everyone since July 1st of 2018. You can find where the statute makes it applicable in 6490-365 sub 1. This used to be found at 6490-080, but the legislature moved it when they were editing WUCIOA this year. Ken, did you have anything to add to that?
No, that's, I think, a straightforward answer. You are required to comply with WUCIOA's budget ratification process. That would even apply to cooperatives. Did we have questions in the chat that we should be covering, or we get to go home early today?
We have a few. So first question that I can see in the chat, and Chelsea, if you have some sent to you, feel free to chime in. As a director, I've contacted our auditor many times asking questions without ever getting answers. The property manager hires the auditor. What can be done? Ken, do you want me to take a stab at this?
Sure.
Okay, so the auditor is hired by the association. If the board authorizes you to ask questions, you can get that authorization to the auditor so they know that you are authorized to ask that question. You can ask the manager if they can have the auditor available for a meeting where you can ask questions, but it all comes down to what's in the contract. So while the property manager probably gives you an option or uses a particular company, your ability to ask questions is contained in the contract with the auditor, and that contract should be with the association, not with the management company. So take a look at the contract, get board authority to ask questions, and then have the manager send those questions over to the auditor. It's probably a break in the communication, and the auditor may not know that you are authorized to ask those questions. Ken, did you have anything to add?
Sure. If you're working with a vendor who is not providing the services you want, then you should consider a different vendor for the next year. And boards should remember that they always have control over the vendors that are hired by their management company. I have certainly seen a couple management contracts which seem to say that the board loses that authority, but I don't believe that's actually true. I think the board always has the authority to engage the vendors on behalf of the association. If your management company is not allowing you to participate, then I might look at a different manager. You should know in advance of the audit being performed what the cost is going to be, what kind of timeline you would anticipate in receiving the audit, and what might be required of you in order for the audit to be prepared. So there's, 2 or 3 big audit firms that do a lot of community associations. And you can find auditors on the WSCAI website.
Okay, next question. When an association has excess funds, is a vote of the members required to roll those funds over into the reserve fund? If yes, what is the voting requirement? Ken, did you want to take that one?
Yeah, there's an IRS ruling from 30 or 40 years ago that does say that in order to transfer the funds, you are supposed to get a vote of the membership. And so if you are following the letter of the law, you should be at your annual meeting approving a transfer of any surplus funds into reserves. And I can't remember the revenue ruling on it. It'd be a fairly easy Google search if you wanted. But yes, there's supposed to be a vote. In, I would say, most communities, there is not a significant amount of money, which is the surplus funds relative to the overall budget of the association. And usually the budget process is trying to also accommodate any surplus funds or shortage of funds from one budget year by correcting it with the next budget year. But yeah, there is an IRS ruling on the transfer into reserves.
So next question. And this is regarding back to the individual owner who's contacting prospective vendors. This person thinks a copy of the L&I report should suffice as proof of insurance and licensing. Is there a problem with that? And first off, if you are in a condo or multifamily housing, many insurance companies have specific disclaimers or exclusions for multifamily housing. So just a report from L&I stating that they have insurance isn't enough. That's one thing that I know for sure. I know Ken knows a lot more about this as well.
You know, that is the key point is we we do rely a lot on L&I. Every time we do a contract review for a client, we go to the L&I website to check on the status of their license, to check on how much insurance they have registered with the state, and to check on whether or not they've been reporting their workers' compensation insurance and the number of employees they have. It's actually surprising the number of contractors who will list 0 employees because they're turning around and subcontracting all of the work, especially roofers. But Jennifer's right. They can have insurance, but have an exclusion for the kind of work being performed on your building, whether it's because they have a exclusion for condos, or they might have an exclusion for doing torch down roofing, or an exclusion for doing plumbing with soldered fittings. And these exclusions are a way for a contractor to reduce the cost of their insurance because it carves out an exception for what might be the highest risk work that they are performing. Yeah, so that's the answer I got.
So the next question. What is the correct terminology for referring to parts of the RCWs? Acts versus sections, parts, subparts. Please provide examples. So using 6434.345 as an example, it's RCW chapter 6434, section 345, subsection 1, subsection 2, subsection 3. And that's just an example off the top of my head. I don't know if those particular subsections are in that particular statute, but it's chapter, section, subsection.
Right, and when you say the act, the Condominium Act 6434 is an act. The HOA Act 6438 is an act. It's in the name of the law.
Okay, so the next question in the chat. Our association has not yet filed our BOI report and a board member recently resigned. Is this person still required to provide their FinCEN ID for the filing? And I believe the answer is no. I know this has been covered extensively in prior Q&As, but the BOI report is the beneficial owners as of the time of reporting. So if a board member resigns before you report for that for your association, they're not required to be on the report. Ken, did you have anything to add to that?
No, I agree with that.
We have another question related to the CTA that would be probably good to cover now. Clarification on the BOIR. The FinCEN website now has a disclosure regarding the need to file a BOIR, resulting in board members taking a wait and see policy. Are we still encouraging board members to ignore the message and file for a FinCEN so a BOIR can be filed?
Well, the lowest risk option is still to file. And I think National CAI is also still advising that the lowest risk option is to report because of the uncertainty about whether or not the New Jersey court ruling or the Texas court ruling will prevail, and whether or not there is ultimately a ruling by a higher level court that this is an enforceable law. The risk is much reduced because of the injunction, but we can't tell you there's no risk. And since most of our clients are trying to pursue courses of action which are the lowest risk to the community, then we would say go ahead and report. We also are still confused at this notion that you are giving information which is somehow secret to another government agency. The only difference in what you're reporting to the Treasury Department is you're uploading a copy of your driver's license or passport, which is already held in the state records. It's just not held by the Treasury Department. All the other information, including your social security numbers, things like that, are held by the government. And if you're using a FinCEN number for each of the individual board members or reporting beneficial owners, you don't have to share any of your personal financial information or your personal driver's license with your fellow board members or your management company. You're just providing it to the Treasury Department.
So next question that I can see in the chat, is there a list of the laws that apply to all associations from WUCIOA? So the list of applicable statutes is found in 6490 365. That used to be 6490-080. So if you look at 6490 365 sub 1, that's where it states specifically that 6490 525 applies to all associations, and that's the budget ratification statute. So
doesn't it also include 545, the reserve study statute?
Yeah, they just, for some reason, the legislature just took section subsection 080 and moved it to 365, but it's the same language as was in 080. They just changed the number.
Yeah, but it's a short list. It's section 525 and, excuse me, 545. And section 545 encompasses more than just that one paragraph because it requires that the reserve study sections of 550 also come in at the same time. That's the reserve study requirements.
Okay.
And remember that in 2028, the HOA Act goes away and everything from WUCIOA applies to your community.
Next question. Do you have a link to register with the Treasury Department? We don't have a direct link to give you, but if you do a Google search or whatever platform you prefer to use and search for FinCEN, F as in frog, IN, C as in cat, IN, look for the .gov, not any other tail on the particular website, and search for FinCEN beneficial owner, you'll find it.
And if you are uploading anything and it asks you for money, you're on the wrong website.
Chelsea, do you have any questions that were sent to you?
Nope, we already covered them.
Okay. And I see some comments in the chat. Someone did put the FinCEN link in the chat. Let's see. As long as no one else has more questions, we're going to be done a little bit early.
All right. Well, everyone have a good holiday and we'll see you after the new year.
Happy holidays.